The General Data Protection Regulation, or GDPR as you've likely heard it called. It goes into effect on May 25th and it could affect you, no matter where you are or where you live. How? Let's answer some questions. So, what is GDPR? It tightens Europe's already strict laws about what companies can do with people's data. It gives you more control over how your data is collected and used, and forces companies to justify everything that they do with it. While GDPR is European Union legislation, it has a huge effect on businesses outside the EU, including the US. Why was GDPR introduced? Because the old laws were written before smartphones started collecting massive amounts of sensitive information for companies like Google and Facebook. GDPR gives organizations guidelines on what they can and can't do with personal data. It also makes them give users more clarity over the kind of data being used and how companies will use it. What is considered personal data under GDPR? Any data that can identify you. That's your name, phone number, or username, but the law also includes things like your IP address or location data. Even tighter rules apply for sensitive information such as sexual orientation, health data, and political opinions. How will it affect you? One way is that you will often have to opt in to letting a company use your data. This means fewer pre-ticked boxes, and firms are compelled to use clear and simple language. Do people have the right to be forgotten? Yes, people can request to have their data deleted. Personal data also needs to be transferable via a common file type. However, the right to be forgotten is not absolute, and certain conditions apply. Why is GDPR a concern for non-EU countries? Because many businesses collect or use EU residents' data. They also use companies based in the EU for services and processing data. What happens if a firm doesn't comply with GDPR? The penalty could be up to 20 million euros or 4% of annual turnover, whichever is larger.
Right. So our session is all about privacy and data protection. And as the video has pretty much introduced itself, we're going to be talking about GDPR. We're going to be diving deeper into that. And hence I have the esteemed panel here. People are going to help us to understand how does this affect us. Specifically within the African context, how does this affect us? How does GDPR actually affect us? So what we're going to start off with is a quick introduction, because I don't think not many people know about yourself and Mr. over here. So Garth, if you could please just do a quick introduction of yourself.
My name is Garth Miller. I'm actually the administrator of a small island country code in the Indian Ocean, Christmas Island. I'm also a project manager for COCA, which is a registry software solution used by quite a few CCTLDs in Africa and the Middle East.
My name is Olunia Jao. I manage Web for Africa. Web for Africa is a leading ICANN accredited registrar in the Africa region and also a web hosting company. Thank you.
Right. There are two more panelists that I'm still waiting for. I know Bob is outside, so we're just waiting for him to come through, and another person from Afrinic. I know Alan is not in, but I was told that somebody else is actually coming in Alan's place. Or am I mistaken, Barack? Jenny. Tijani. It's okay. Okay, cool. All right. So, Garth, let's kick off with you. What I would like you to do is, ideally, take us through how how does GDPR affect us, or rather within the context of a registry in Africa? How does this law now affect us as a registry operator?
I think maybe if I could tie it in a little bit to even the preceding session, which was helpful. One of the biggest challenges for the industry is actually building consumer confidence and interest in our domains that the registries or the registrars provide. And the two sort of trending issues in the industry right now are really security and privacy. So GDPR is really a European law, but it was drafted because of concerns of citizens in Europe. And those concerns from citizens who are also the consumers are universal. So it's not something that really, as a registry operator, that you should be concerned about, how do I comply with this law from another jurisdiction? The question we should be asking ourselves is, why was this law drafted or enacted elsewhere, and how does that impact me put me at a commercial risk, or my supply chain at a commercial risk? But also it gives us an opportunity to look at our policy, because there's a tendency in this industry to always do what we've done in the past and always collect data. And I look at the GDPR as an opportunity for registry providers to say to ourselves, well, why do we actually collect this data? Why do we need it? Just because people who started Internet and .com 20 years ago used to collect technical whatever, and we've all been following this same pattern for 20 years, it's an opportunity for us to look at why we collect this data. I was sort of interested, tying in with the earlier presentation, when the .Africa registry did their presentation on their proxy service. One of the things was you had to upload your passport or ID. Yeah. And my question is, well, can you validate whether it's a real passport or ID? There's no one there that can actually tie into a national database and do that. Why are you collecting a copy of my passport, and what happens to it once I give it to you? You know, like, what happens? Does it just sit on someone's folder on their hard drive and someone hacks into it and now they've got the passports of, you know, all these people? You know, so these are questions which are legitimate questions for a consumer. So just to answer your question the roundabout way, the real question is, if you're trying to grow your business in Africa as a registrar or as a registry provider, your supply chain, because of the domestic market, is generally not as advanced as it might be in Europe or Scandinavia. A lot of registries in Africa do accept registrations from outside of their jurisdiction. So the GDPR affects your supply chain. If you have a registrar or a reseller in Europe, or you have a contact who is in Europe, the law applies to them. So it's really the concern as a registry operator is that you need to protect your distribution channel from liability. So if you have a European registrar or reseller, they are at risk. So because they are your supply chain, you need to protect them from that risk by complying with GDPR as a registry operator.
That's very interesting, because subsequent to that, my next question was going to be, especially to Olini, is that how does GDPR affect you as a registrar, or should I say an ICANN registrar based in Africa? I think Garth has slightly alluded to a solution to that, but if you could please just take us through that as well.
Okay, thank you. Yes, from my work with Web for Africa, it happens that we have clients across the world in over 100 countries. So obviously some of them are in the EU, some of them are based in the EU, but then like 80% of our clients are in Africa itself. So I feel like the impact, if any, of this law, of this regulation on our business will be minimal. But the strongest area I have seen regarding GDPR in Africa so far in African DNS industry so far is with the WHOIS record. So I noticed that many of the registries were scrambling to make themselves compliant with the regulation. For example, about over a dozen registries in Africa make use of the COCA system or the COCA software for running the technical aspect of their registry. So a particular registry that I deal with a lot, .ng, I made inquiries in order to know what they are doing, and they said the software has been upgraded in a way that a domain that is registered by a resident of EU doesn't display much data in the WHOIS record when one queries it. And I was also able to verify that, and I also noticed that another registry, ZDCR, they also redacted most of the data in their WHOIS record. So when a person is querying the WHOIS database for domain ownership, the domain industry is another aspect of the impact is that, for example, people who are domainers, they register domains with the hope of reselling it, would now be necessarily forced to sell it through a domain platform, a domain marketplace platform like Sedo and the likes, because now a person who is interested in a domain name cannot just go to the WHOIS database to see who the owner is in order to contact them, unless the domain is listed on a marketplace. That's the only way it seems like they could contact the domain owner. And another smaller aspect, like I said, the WHOIS thing is the biggest impacts on the industry. A smaller aspect is the control panel that the registrars run. Now, in most cases, the registrars are using an off-the-shelf software. And it so happens that the developers or the vendors of this software have also upgraded their platforms to make sure that they are compliant with GDPR. So a registrar who keeps their system up to date would also benefit from the updates. So eventually, if an EU resident or otherwise chooses to request for their data, or chooses to download their data, or chooses to delete their data from the registrar system completely, it's now possible for a registrar that has upgraded. Now, another aspect on the domain industry is a value-added service called WHOIS protection. Now, this is very common with GTLDs, in the sense that a registrar could offer WHOIS protection or privacy protection, or they call it so many names, ID protection, such that a domain registrant can choose not to display their data publicly. This has existed for over 10 years now, but I feel that the GDPR would make that value-added service redundant. So eventually, it's possible that in a few years' time, people would, when they get to realize that, oh, the GDPR is doing the same thing that WHOIS privacy was doing, they might stop buying it, and that might impact the revenue for the registrar. Considering the profit or the margins on the domain business is already very small, probably this value-added service were one of the ways that registrars were augmenting their income. So I feel that could be an impact on the market down the line. Yes, I think those are the few notes I have so far. Thank you.
Thank you so much, my good sir. All right, we've just been joined by Tijani from Afrinic, Afrano, pardon me. All right, so Tijani, how does GDPR actually affect us within the African context? It's pretty much the topic that we're having on the table right now. And I can see you've already set up your notes to actually speak into it as well. Can you just take us through that, please?
Yes, thank you very much. My name is Tijani Benjamin. I am from Afralo. I have just been informed that I have to speak. I wasn't prepared to speak at all. So forgive my perhaps non-preparation for this intervention. I don't know if we spoke about GDPR, what is GDPR and how it came, etc. I think it is important to inform our audience about that. But if you already did that, I will not come back to it. Did you do it?
Well, pardon me. To those who came in late, we had a video that actually explains. Everybody hear me?
I think we're back.
Okay, now it's good.
Well, my other job is I'm actually a pastor, so I can actually speak, to a crowd. So I'm not going to do any offerings, though, I promise you. To those who came in late, we had a video that explains what GDPR is. But to the benefit of those who came in late, if you could please just take us through an explanation of that.
Okay, thank you very much. So, the GDPR, the General Data Protection Regulation, en français on dit le Règlement général de la protection des données personnelles, was adopted by the European Parliament in April 2016 and entered into effect a few weeks ago on 25 of May 2018. It's an European law applicable to all member states of the European Union. It's not like the directives that the European Union used to use before. It was something that the member states have to adopt their law according to the directives. This time it is a law that will be applied to all member states of the European Union. The GDPR imposed tough requirements for data collection, data storage, data processing, data retention, and data transfer. According to GDPR, personal data couldn't be collected without legitimate purpose and without non-conditioned consent of the subject. That means that if they will collect your data, if you don't agree to give this data, they will not collect it. And you don't have to agree because you are obliged. You have to agree freely. Okay, the collected data can only be used for the legitimate purpose they were collected for. The GDPR also forbids the retention of data when the legitimate purpose they were collected for is not valid anymore. It requires that the data is destroyed as soon as the subject stops its consent or his consent. The non-compliance with this law implies fines that can 4% of the global annual incomes. How the GDPR will affect how the GDPR can affect the internet community. The most important, as he said, the most important effect will be the data of the registrants, the WHOIS data, because this data before have always been massively collected without limits, and they were open to everyone to be consulted. So all data of anyone who has a domain name are public for everyone, and the number of this data is more than needed for the domain. So the GDPR posed several questions regarding the collection, the retention, as I said, etc. For the record, since the first days of the ICANN, discussion around WHOIS data have never stopped and didn't lead to any consensus. During this discussion, a proposal for thick and thin data have been made, so that the registry will have only thin data, means a reduced number of data, and the registrar will have the full data. But as you know, it didn't work. Okay, I will skip this. This time, there is a pressure of time, and there is, since the GDPR entered into effect on 25 of May, ICANN was pressured to find a solution how to comply with this new law or this new regulation. So there has been a lot of discussion inside ICANN, and the executive of ICANN, if you want the staff, the ICANN staff, have found a proposal, a model for compliance. The first draft of this model was discussed for a long time in ICANN among the community, and then they come up with a new model that they called cookbook, and then now the last version is the cookbook translated into legal language, and the name is now temporary specifications. So ICANN today has temporary specifications for the WIS data. How it will be compliant with GDPR or not, this has been discussed for long also with European parties, especially the data commissioners in Europe. And now I think that there is more or less an agreement to the proposal of ICANN, and they said it might be compliant. But anyway, this specification has to be reviewed each 90 days, and they cannot stay more than 1 year, because it is an exceptional way. The change of the registry and the registrar's contract cannot be done except if there is a policy developed by the GNSO and adopted by the board. This time we didn't do that because we didn't have time. It was an exceptional way to have this compliance. So now today we have those specifications, those temporary specifications. We also have a proposal for access, a unified access model. It is just a proposal. We need to have all the community adopted. That will lead to several kind of accreditation models according to the situation. So this is the case for ICANN. Now, since the duration of those specifications is only 1 year, we need the GNSO to develop the new policy and have it adopted by the community and by the board in 1 year, starting 25 of May. So it is very tight timeline, and now the GDPR will have an expedited policy development process to come up with this policy, and I hope they will manage to do it in this period, very short period. So now for Africa will be affected as any other community, as any other region, if the African industry, DNS industry, is serving Europeans or resident in Europe, they have to be compliant with GDPR. If they are not serving those people, they may not be compliant, and they may stay as they were before. But I will tell you that in the future we had better to be compliant, because I think that we are going towards something like this for all the world. I know that Canada has now their model. A lot of countries are working on data protection system that protect the personal data. I can stop here.
Thank you so much, sir. That adds so much clarity. If I may, Web for Africa, how are you ensuring that your registrants are also equipped with the changes that are happening within the industry? I mean, right now we're talking about GDPR, and I'm sure not many registrants actually are aware of GDPR. I know that registrars tend to send an email to say, please make sure that your contact details on who is up to date because of this policy 123, and I'm sure many of them actually ignore it. So how are we making sure that registrants are actually informed and educated about the changes that are happening?
Thank you. Yes, there's a requirement by ICANN that the details published in the WIS record must be correct and up to date. So on that front alone, we are compelled by regulation, by ICANN regulation, to ensure that these details are correct. For example, one of the things I know is that when the email address is invalid, after a number of days, the domain is going to stop functioning. So before GDPR came, we had already had mechanisms of ensuring that the data that is used for registering the domain names were valid. Now, in terms of the GDPR itself, yeah, like you pointed out, what we did before the date was to send out notifications of information about GDPR and the changes we would be making to our systems in order to be compliant. Yes, so like most other service providers, around that time, around 25th of May, I was getting a lot of emails from just about every provider of service and social media network about GDPR. Yeah. We were also sending out email as well. That was the best we could do. And currently on our WIS page, we explained what is going on, so that when a person is querying the WIS data on our own website and they see that most of the information is not revealed, they can click on the GDPR link and understand the information or understand the reason behind it. Yes.
Thank you for that. Very interesting. So if I may put the CEO of ZACR on the spot here for a sec. So in most cases, when people want to verify details of who actually owns a domain name, they tend to go to the WHOIS. And as Web4Africa has highlighted, ZACR has already made sure that you can't necessarily obtain those details as one used to. So now let's say I want to verify, or I'm an official and I want to verify the details of who owns this particular domain name, or this domain name actually has been involved in fraudulent activities. What are the steps that I need to take now, considering that GDPR is something that you are complying to? Not yet, sir. I'll tell you.
Look, GDPR has just recently been thrown on us, and we are working towards ensuring that we are fully compliant. So the steps towards compliance at least have been starting with redacting section data, and then seeking consent from the owners of the data, so they understand that the data is being held by us, and it will only be used for what it is meant for. And we state equally that then there's going to be instances where authorities would request for us to disclose that data. Now, the procedure there is almost accepting. The authority will be identifying themselves that this is, if it's Interpol, they will identify themselves as Interpol. If it's a local security intelligence or any other security cluster, they would identify themselves. Then we would have to comply and provide them that information for whatever they need to be doing. So in terms of process for that, we don't have it, but we are clear that we would identify those security clusters that will be requesting the data for whatever reasons, and then would make it available.
Thank you so much, Mr. Masilela. So what I'm trying to achieve is to gather perspective on GDPR, and to gather how it affects us from a perspective of the registry, from a perspective of the registrars, and also now we've just heard from the perspective of ICANN as well. So with that said, I'm opening up the mic so that now we can be able to engage the panel. So if we would, if you have any questions, just raise your hand and we will recognize you. My leadership. You're on. Thank you so much.
Oh, okay, thank you. So my name is Mohamed Diop from Senegal, and Chairman, excuse me if I just want to challenge the title of this session is more about not only GDPR, but we open up to other systems that are related to privacy and data protection in our environment, because we don't have an empty land here. So GDPR have been drafted and validated by the European Commission, but in our different countries we have many commission, many laws that have been passed related to data protection and privacy. Yeah. So I think that this session is intended to be broader than just GDPR, but we really need to understand on the GDPR what have been done, but also on the other side, like in Senegal, the CDP is the commission that have done a lot, and because the goal was the same, is regarding the protection of the registrant. So I have one question to the first panelist from COCA. First of all, congratulations, because your product was very useful for many registries in Africa, and this has been very helpful for the automation of many systems here in Africa. So we congratulate you for that job. So beside that part, so my question is, COCA have been set up in different registries, and the baseline is here. So when you have seen that trend in the GDPR compliance, what have been done on the development side to allow countries who want to change the code or doing something specific, did they have a chance to go through it, or is that something that needs really to be done by the developer, or is that a community-based movement that need to be done in order to make the product compliant with all the regulation that can be based on European requirement, or even some local adaptation that need to be done in order to be compliant, because this environment is going to be more and more complex, and we need to have products that become more and more flexible to allow local adaptation. Thank you.
Yeah, thank you for the compliment. So when we made the changes in COCA, it's currently used by about 50 CCTLDs globally, all of them with different policy matrix. So we don't support different versions of the software. We put all the possible options in. So with regards to the privacy aspect, we didn't come out with a version that was GDPR compliant. We came out with a version that enabled the user to configure it to be GDPR compliant. But in a sense, it's universal. In other words, you can enable or disable display of certain functions. You can enable or I guess one of the key things of GDPR is that you shouldn't be collecting data that's not useful. The concept is data minimization. So within the software, a lot of, historically people have collected billing information, and that's just the way it's always been done since, mid-90s. Some CCTLDs still do, but in a context of a registry-registrar model, we're not sure that the actual registry has a need to collect billing information because they're not billing the registrant. So there are options in the software to say which data objects you want to collect, yes or no, which data objects you want to display, whether it's a European or not. So essentially it's completely flexible. There isn't a version that's GDPR compliant that forces people to be compliant. You can just configure it to your leisure. In the model that we're using, we distinguish between European registrars and their resellers and European contacts and people outside of that. So it's sort of a hybrid model where for a lot of, if you're a Canadian registrar and your clients are in Canada and you're registering a Christmas Island or East Timor domain, there's absolutely no change to the whois. So we went for a quick compliance, which enabled our users to not disrupt their supply chain by getting their registrars upset and facing liability. So the main concern, or the main motivating factor, was for small registries that have the bulk of their revenue coming from outside of their local community. we wanted to make sure that that supply chain wasn't disrupted, that those registrars were comfortable continuing to sell the domains and didn't face a legal or commercial risk by doing that. That was our first step in sort of mitigating it, and there'll be more versions with additional features, as the market matures and the regulation becomes more stable. But I think to the point earlier is that even though it's a European law, every country has their own rules and regulations, and we shouldn't, I think as registry operators or as regulators, we should all be moving towards the objectives of GDPR in any event. So it's a good opportunity for us to look at these issues, and it created a good excuse for lots of people to actually expedite review of privacy. I think that was the most valuable thing. If you just want to say, well, we just want to review privacy and there's no motivating factor for it, you're unlikely to get change. So in a sense, I'm thankful for the GDPR because it gave everybody an incentive to revisit their policy.
Merci, cher.
Thank you. I'll react to the consequence of DGPR, the function and legal models. I think the DGPR is not GDPR. It is you have different collection processes, right to forget. As registers, for us, we have to register from non-registered non-European, so the requirements are not the same as the non-registered European registrars. Some of them are compliant with the ICANN rule concerned with, and we have different rules that are not 100% compliant with ICANN. Certain difficulties have come with ICANN. Like they had the issue where German registrar didn't want to take register data in order not to be taken into account. That will lead to certain discrepancies of other modes of functioning. Some of our registrars, for example, ask us if we have a DPO. That is not a requirement in our laws in Senegal. That's a European setting. So having a necessarily a data protection officer, we need to comply with a commission, a regulatory entity on data protection, but not in operational setting. So we have issues with compliance. If you have clients, if you have clients who want to trade with Europe, it's not technical. There'll be more important consequences than shielding or not shielding data for providing data. That requires us to focus originally. I think FTLD must focus on that because we have a lot of our registries that work with registrar that are under the GDPR. We have clients in Senegal, for instance, the call centers that are compliant with GDPR, going through our registries where we collect data that they have. So the complexity is not so obvious, and I think that we should not just shield it. There's a lot of work to be done. I want the African community to really commit to the rules of setting up GDPR in ICANN and follow closely what has taken place between both legislations to ensure that we are able to function in a sovereign manner. Europe must not dictate to us the way we manage personal data in our jurisdiction. Europe has its obligations. One should not become the one giving orders to the other.
Thank you so much. Do you want to address that?
Merci beaucoup, Alex.
Thank you, Alex. The difficulty is that currently we have a hybrid model, as the gentleman just said. There are people who are talking about fragmentation. It is true, because even the specifications, the temporary specifications that ICANN just adopted, clearly tell us that this must be done for all European clients, but it's optional for others. Therefore, each does what suits them. So there's a landscape that is absolutely, if you are, it's an equation with many unknowns. So this situation is dictated by a situation of fait accompli. They are telling us that Europe should not dictate to us its rules. Europe is not dictating the rules. Europe has adopted a law for itself. So it only concerns its citizens and those who live in Europe. So if you're not there, if you don't serve European clients or clients that live in Europe, you are free to do whatever you want. Just that you said something very, very interesting, in my opinion. Personal data protection is something essential in the lives of people. You saw what happened during for the Facebook and the issue of the American elections. Personal data that were used to campaign. So the personal data protection is essential, but other things should be taken into account. Nevertheless, the use of domain names in a criminal manner must be also considered, and that's why we do not just look at the personal data protection area, but also protection of people against crimes that are perpetrated through domain names. That's why when we say collecting data based on a legitimate approach, we need to must consider all legitimate reasons, including protection against crimes. So it's not as simple. It's very complicated. It's something that we must work on quickly, in my opinion, on our continent. We are also concerned with data protection. In Tunisia, we have a data protection agency, a personal data protection agency. I believe in Africa, elsewhere, there should be. What we need is to unify our efforts. What we need is to harmonize our laws such that we are able we are compliant, first of all, with European law, because it's not a bad law, and because we have clients, people we work with who are in Europe, so we have an interest in our laws covering their requirements, and by so doing, if we're able to harmonize, we're going to feel at ease in our transactions anywhere in the world. And I assure you that this trend of protection, personal data protection, is evolving, and you see other laws that we must respect, that everyone must respect, if you want to serve those clients. And I believe that we're going to get to the harmonization of all data protection, personal data protection laws.
I do believe we have another question from the floor. No, the gentleman has a mic. Sorry, ma'am. Gentleman has a mic.
Oui, bonsoir. Je suis Raoul Echede.
I'm Raoul Echede. And I would like to start from a little story. After 25th May, the activation, the implementation of the GDPR, I opened one of my Yahoo mailbox and I received a notification. I said, oh yeah, I need to update. Generally, we just click OK and we move on. But then, out of curiosity, I decided to read through. When I look at the details, I felt, oh, all that was being collected. When I started on ticking, a question came to me. When I said if you untick that, because the one who offers that to you, the one who offers that to you leaves off that. So if you untick it, what will happen? And I realized that the data collection they were collecting was supposed to improve my customer experience. For instance, if I'm more into football, I receive more adverts on football and rather than something else. And I felt if I untick it, what is the user experience that I like to have while using this service freely by unticking the part that could really bring some income to the one that sent it to me. I realized then that everything free has messed up our consumer habits, and my question is addressed to the content supplier, not the right managers that know they are legal brains and they will tell you that that's right or not. But now I would like to talk to the content producers, content developer, or even registrars on the panel. I would like to ask, what is the alternative that you are using when you, with the coming into force of this law, to fine-tune, refine the user experience for your customers so that there's no advert of horses done rather than something else, and what a technical model that you set up to replace this option, because people have the possibility of saying this or that, but in place of that, what do you offer them so that they are not lost? This is part of my concern. I will stop for now.
Thank you so much for that question. Can we please pass over the mic to Mem over there?
Thank you very much. My name is Tandim Vundula. I'm from Malawi. I had a couple of questions that I needed clarification on. With regard to the GDPR, is it only, while it's for the developed for the European Union, does it only affect people in the European Union, or does it affect citizens of the European Union outside of the EU, who are residing outside of the EU, because their data would be collected in a different jurisdiction to the one they may currently be living in? And what would the legal impact of that be? I'd also like to check, because I have noticed some of the, using the WHOIS, I've noticed that some of the domain names have got information redacted. But how does that affect squatters? Sort of domain name squatters, because now you don't know who it is, you can't get access to information on it. How does that enable the registrars to actually manage that? Thank you.
Thank you so much for that question. That was actually a powerful question as well. Do we still have any more questions? All right. Shall we start with Mem's question? Can we please address that?
Thank you. If I understood well your question, is it, does the GDPR apply to all people, or is it only restricted to European people? This is your question?
Members of the European Union,
yes, okay. Okay, yes. It applies to all European people, and also people who are living in Europe. So if you are serving this kind of people, you are obliged to be compliant with the GDPR. If you are serving people who are not there, you are free.
But if you're European and living outside of Europe?
Yes, they are covered by the GDPR.
If I could just add to that as well, it applies to European residents, not just citizens, but also applies to the location of the data collector. So if you're collecting data as a European entity on non-Europeans, that data is still protected. So the GDPR protects non-European residents or citizens if your data is collected by a European company. So the prohibition is not just against display of information from or collection or aggregation, it actually applies to European companies. In other words, if Facebook was head office in Europe or whatever, any data they collected on anyone in the world would be applicable to GDPR. So in our industry, if you have a registrar or one of their resellers, because now you have these large gateways, even if they're collecting data and they're in Europe, even if the registrant is non-European and outside of Europe, but the data collector, the registrar, is in Europe, that personal data of the Canadian or the New Zealand or whoever is protected by GDPR.
If I can take the last part of a question, she was asking about domain squatters. Yeah, I wish to point out that it's not the entire information in the WHOIS that is hidden. It's just that most of it is hidden and mostly personal information. So most of the times, the name of the registrant is not hidden, or the name of the company, if the ownership of the domain is a company, that is not hidden, and also the registrar details is not hidden. So in most cases, if there's a legitimate need to contact the owner of the domain name or to do some investigation about this domain name, one can always contact the registrar directly, and depending on what the issue is, the registrar can offer some help.
You had a follow-up?
Yes, the GDPR applies to personal data, not company's data. So if the company data include the name and the address, email address, telephone, etc. of one person, it will apply to that. But for other information, no problem with GDPR.
Okay. Sorry, Garth, you wanted to add something else?
Sorry, just to follow up to the point that you'd made about the information that's made available on the WHOIS database. I came across one that didn't indicate the company and only indicated the location, the country location, and that was it. So otherwise the rest of it was blank, apart from, of course, the redacted information. So it's not consistent in that respect.
Yes, to be very fair to the registries, and to ICANN, the industry is still trying to distill how exactly this GDPR would apply to the domain industry. So to a large extent, the different registries are taking slightly different steps. They are reacting slightly differently. There is no uniform reaction to it currently. So it's understandable that you would find slightly different applications of the regulation. Some would hide the volume of information they hide varies. Yes, that's the reason.
Yeah, just to be completely candid, I think it's very rare that a criminal actually puts their real contact and phone information in anyway. So, so this idea that somehow the WHOIS database and this information is hugely beneficial to law enforcement, I think is really, it's sort of a bit of a red herring. I think the information and the people who are really concerned about GDPR are the intellectual property owners that are looking for people that are registering names in violation of their brand. And the database that's most useful for them is actually the zone files, which do not contain any personal information. So in the case of Christmas Island, and we have about 20 CCTLDs that we work very closely, we provide the zone files to a Canadian company, Secure Domain Foundation, which is a public benefit company for domain name abuse. Look them up, Secure Domain Foundation. And if law enforcement or intellectual property people are concerned about someone abusing their brand, they can get the zone files from the SDF. And that's generally the first port of call of where if you're looking to mitigate abuse, you want to know if someone's registered your brand or your domain. You don't need the personal information to do that initial automated comparisons. Maybe just one briefly, that'll be what ICANN is proposing in the GTTLD environment is basically some sort of model where you have accredited law enforcement or intellectual property people who will be able to access the redacted data. But there's no proposal at all in the CCTLD environment for this kind of aggregated database or access. And that, I think that's something that maybe AFTLD or as an organization, we need to look at how we provide access to accredited individuals for private data that's outside of the ICANN environment, because there's absolutely, the contentious issue is on the ICANN side, but there's absolutely nothing being discussed for anybody on appropriate mechanisms for accessing this data in a CCTLD environment.
Okay.
Okay, thank you. The unified access model has not been yet adopted. It is now for discussion. So if you have this kind of proposal, don't hesitate to give your opinion so that, because it is not yet adopted, and the unified access model will lead to several different accreditation model to access to the public data, to the non-public data.
Right.
Question?
Yes, sir. Okay.
Yeah.
Let me let you through.
Thank you, Lucky Masilela. To the panel, and this is more a follow-up to what Mohammed was saying, that it's not GDPR purely, but we have other data regulations or data policies across the continent, and starting with the African Union, you know, there is your Convention on Cybersecurity and Personal Data Protection, and South Africa, and I think 16 other countries on the continent have something, you know, to the protection of personal information.
Yes.
How do we weigh that against GDPR in terms of managing and containing the protection of data, you know? And this is also pretty much to what you have just said. This addresses your GTLDs. It doesn't talk to the CCTLDs, but there are countries that on their own obligation decided that they must apply this blanket policy across both your GTLDs and CCTLDs. What is going to be supreme in this instance? Your GDPR or the country policies or the continental policy in this instance?
All right. If we could please give the mic over to Bob. But Bob, before you even raise your question, firstly, my panel, you got that question from Mr. Masilela, right? Okay, I'm going to ask you to address it a little bit later on in a few minutes to come. A question that I want to throw back to the audience is pretty much building up from what Mr. Masilela just raised and what Mohammed raised earlier on. We're discussing GDPR. And yet again, we already have laws that already exist within individual countries within Africa. We're discussing GDPR because it seemed to be effective in terms of the way it's been implemented and also the consequences that will follow people who do not comply to it. So therefore, how effective are individual laws in individual countries in Africa when it comes to data protection? To a degree that we're not even discussing them today, but we're actually discussing GDPR. How effective are they? I'm throwing it back to you. I know in South Africa we have Poppy. How effective is it? Mohammed? In your country, what is the law and how effective is it?
Alex is not suitable to answer that question. You know why?
Chairman, Alex is training the Commission for Data Protection in my country.
Okay.
So he's more knowledgeable than me regarding that question. But if you want me to give you my point of view as a citizen, is that what you're expecting?
Yes, please.
Okay. To be honest, it's a false balance that we've seen here. Even the US is in a very tricky position when it comes to deal with the European Union on the GDPR, because ICANN is under US law. And we are contractors to ICANN. But if you see the situation, they have some registrar that sue ICANN in Europe to say that they don't want to no more deal with these things. And we don't have, and the court accept rule for the registrar, and ICANN is in trouble, so they are trying to do an appeal. But in fact, what does it show? It shows that you have different jurisdictions with different power, and we're going to see a balanced power. If Africa did not show up, we got a chance to have an African Union, yes, but what the resolution of the African Union represent in terms of national enforcement? Because sometimes the African Union set up something, but the time it becomes a regional jurisdiction and it goes drill down to a national adoption, it took a while. Cybersecurity conventions have been signed at the African Union level. It means head of state have endorsed it. But what was the implementation plan per country? Because when we talk about CDP, like data protection law per country, it's a local implementation regarding the local jurisdiction. And this is a huge implementation job that needs to be done. In my country, I can tell you that in 2009, there was a huge effort of trying to implement this privacy with the change on the law to introduce electronic, to introduce modification regarding electronic communication, data privacy, data protection, and this is when they set up also this organization to protect users, but it took time for the implementation plan. Sometimes they decide, but multinational companies who are based in our environment are not ready to follow sometimes the local rules. So here, what Alex was saying is, we are moving into a direction where there will be huge movement and based on balanced power. Because I'm seeing many registrars that will be facing a huge problem because on one hand, you got a contract with ICANN. If you don't fulfill the contract, you got a problem. If you fulfill the contract and you respect ICANN contract, you're going to be against local law. And we know that local jurisdictions are predominant on contract. So that's the problem. So we need to see how our local jurisdiction has to be shown as stronger than any international convention or contract that people can put on the table.
Sure. Thank you so much, Mohammed. Any follow-up to Mohammed's comments? Sure. Bowman.
I was going to say, any contracted parties with whether it's a registry or registrar with ICANN, there is a clause in there that says if they're obliged to follow local law and local law overrides the ICANN contract, they're not in breach of the contract. So in a sense, the ICANN contracts are never overriding local law. They're drafted in such a way that local law prevails.
I feel like Mohammed wants to follow up on that. A quick one, Mohammed. Oh, have you given the mic to Barak already? All right, sorry, let's have a break from your comments, Mohammed, for a sec. Barak?
Okay, I just wanted to read the comments from the chat from Henriette. Even though Mark Elkins is asking whether we are GDPR compliant by mentioning the names. She says, in a way, she agrees with Garth. We seem to be moving towards compliance if you look at most of the African countries, even though we may not have implemented the GDPR in the place. I think that's what I'm picking from the comment here.
Thank you so much. You want to add? All right. Can we tackle the question that Mr. Masilela raised just a few minutes before? No, so we'll come back to the data collection one. Yeah.
Which is the question?
Mr. Masilela, can you refresh or rephrase your question earlier on?
30 seconds. Mic.
Sure, Mohammed, go ahead.
Okay, I have the mic, so 30 seconds. Do you think that the old WHOIS system, if it is broken, do you think that the role of what we try to achieve with this WHOIS system will survive if GDPR is implemented the way it is recommended? This is the biggest threat. And if it is not the case, do we think that we can have a strong DNS system without that reliable information available on the WHOIS to everybody working on it? This is really a big challenge.
Yeah, I guess at an abstract level, I think it's a good opportunity to understand why we have the WHOIS system at all. If you look at a standard zone file, there's a hostmaster email address in the actual zone file. And criminals aren't putting their correct phone numbers and addresses in there. So what the legitimate purpose is for the WHOIS system, as far as displaying any personal data, to be honest, I'm not convinced there is a valid argument for displaying anybody's personal information at all. But I do think there is law enforcement and people who are trying to mitigate cybercrime, they have an interest in knowing what the DNS information is, who's running the name servers, what domain names are registered. This is the critical information, not so much who the registrant is. So I guess if everybody says the WHOIS is broken, I think it's probably worth trying to step back a bit and figure out what the actual point of the WHOIS is. I think there's lots of things that can be, as far as mitigating crime and abuse in the DNS, that can be accomplished without publicly displaying everybody's information. I don't really see much point in it, to be honest. Yeah, I think, sorry, we sort of skipped over you and got drawn away there. I think to answer your question, as far as registries don't really collect that kind of information on uses patterns. So as far as people like you are saying with content, even at the registrar level, as far as I think you're really looking at carriers and telcos and these sort of things providing content, which is outside of the scope of what anybody at this level does. So I think it's hard to answer your question because the sort of information that you're wondering about whether we collect or what we do with, we don't actually collect as either a registry or a registrar. So I think a web hosting company or somebody like that would be the appropriate place to better position to answer that question.
Okay, Bob?
Okay, two quick questions. Maybe if the panel can just clarify. I think we've talked about personal data as far as GDPR is concerned, that we mean natural persons and not corporate citizens of the EU. If that can come out clearly, whether both of them are covered or only natural persons. The second one is, does the industry see the emergence of the heavier push towards tighter data protection laws and privacy laws as a threat or as potentially going to affect the industry negatively from a business perspective? Is it a potential risk we are looking at going forward? And if so, in what specific sense, so that maybe the industry could look at how to mitigate that? Because I think at the end of the day, we want to ensure that the business still thrives. So to what extent is this negatively affecting the DNS business? If the panel, anyone can attempt to address that.
All right, Bob, I need a huge favor. Your mic it's not clear.
Yeah, this mic should be eliminated.
So if you could please just raise that question one more time so that my panel can thoroughly understand what you're asking and so that they can be able to address it properly. Do we, by any chance, IT guys, do we have a clear mic by any chance?
Come up here.
Or come up here. Super.
Yeah, two quick questions. The first one was asking the panel to, if possible, just confirm and clarify in terms of GDPR. When you talk about personal data, you are talking about natural persons only, or natural persons and corporate citizens, meaning an organization. Data is also covered, so that will be a corporate citizen. The second one is, do we feel as an industry that these laws are potentially going to affect the industry negatively? And particularly if so, how can the industry or players in the industry begin to plan to mitigate such effects so that at the end of the day the industry still thrives even with these laws in place?
Question.
Yeah, just to answer your question, yeah, it applies to personal information, not organizations. So if you're a company, an entity, a school, you're not protected by the GDPR. And I think one thing that's important to make the distinction with is between data collection and data disclosure. So I think there's a legitimate purpose for registries to collect information because we're the authoritative database about who the domain name registrant is, if you want to get a secure certificate or these sorts of things. But what we're talking about, the contentious thing is whether it's appropriate to disclose that data to anybody who wants it. My personal view is that I see a legitimate purpose for collection. I don't see a legitimate purpose for publishing my home phone number to anyone in the world who wants it, just because I registered a domain somewhere. So the follow-on from that, I think, is I think if we're looking at the challenge to the industry, in my view, is to find the utility for domain names in an environment where Instagram and everything is becoming more popular. So the challenge is really on the consumer confidence side. And I think if we can provide a high level of privacy, particularly on the disclosure side, that only benefits the industry as far as the end users, the consumers. If they have increased confidence that we're not collecting data and selling their data and doing whatever, I think that's only a good thing.
Thank you so much, Garth. I'm looking at the time, and we're actually dipping into tea break. So if I could please have closing comments from my panelists, I would really appreciate it. 2-minute closing comments. Okay.
Okay, in closing, I don't think GDPR is going to affect the industry in any big negative way. If anything, it could be other factors, but perhaps no GDPR, especially when the industry is getting to a point of compliance. Because one thing I've felt from this room so far is that the volume of information that was being shared in the WHOIS database was too much. So if now we are being compelled by an external factor, in this case the EU, to reduce the volume of information that is being shared, it can only get better, in the sense that the consumers can then probably trust the industry more and not be nervous about giving their correct information to the registrars. Thank you.
GDPR is not protection of registrant data only. It is about any kind of data. Nothing to do with internet. Internet has its case, but it is applicable to all other kind of data. And as I said at the beginning, it is applied to personal data, personal. For companies' data, for entities' data, it is not applicable. It is only to protect the data of persons, of human persons. So this make it very particular, because sometimes even the data of companies are very sensitive, and perhaps they are not to be published like this. But this GDPR, this law, doesn't cover that.
Yeah, I think Yeah, I think it's a good thing for the industry. I think increased privacy is good for society, and if our industry can actually demonstrate to our consumers that we take their concerns seriously, that's only a good thing. So I think the only challenge is how to address the legitimate concerns of regulators and law enforcement, and how to give them access to data that's not publicly disclosed. But I think once we can resolve those issues, I think the whole issue of who is and fracturing of a who is going to go away.
Right. Thank you so much. We've come to the end of the session, but I feel like there's still more that can actually be digested through this. This topic is so huge that we need to deep into it even further. But unfortunately right now we're limited due to time. Ladies and gentlemen, thank you so much. I think now it's time for a tea break.